Thank you for coming out this evening. My name is George Spees. I'm the Chief of Outreach and Training with the Pennsylvania Office of Open Records. In addition to the live audience, I understand this session is being recorded for streaming on the net and your network. So we have a lot of material to cover in the next 2 hours, essentially 4 hours of information in a 2-hour window. So if I talk fast, bear with me. If we have questions during the session, feel free to pipe up. If it looks like we're pressed for time, I'm more than happy to stay here after the session is completed and address any specific situations that you may have. So let's just go ahead and jump in. We'll start with the right to know law. The right to know law as it currently exists became effective in January 1st of 2009. Prior to this law, there was what was called the Right to Know Act, with its genesis going back into the 1950s. Now, under that act, if I were a citizen and I came into the township and requested a record, and let's say for any reason I was denied access to that record, the burden was on me as a citizen to go before a judge and make my case, prove why that record should be released into the public domain. January 1st, 2009, that changed 180 degrees. Now, under the current right to know law, if I'm that citizen and I come to the township, request a record, and let's say for whatever reason you deny me that access, you bear the burden. The township bears the burden of proving to either a judge or more likely an appeals officer as to why the record should not be released into the public domain. So the presumption is that the record is public and should be released unless you can make a legal case otherwise. The other thing that happened with the creation of this law, or the enactment of this law, was the creation of the Office of Open Records, which is where I work. Prior to this, there was no central office or department that oversaw access to public records either at the state or local level in Pennsylvania. The best way I can describe the Office of Open Records is, depending on our focus, we are either a law firm or a court, given the activities that we do. And hopefully throughout this presentation, you'll get an impression as to why I say that. Now, if you are subject to the right to know law, there are some obligations that you have to meet. The most important being that you need to appoint an agency open records officer, or what we call an ARO. This is the person responsible for receiving right to know requests, processing those requests, and then ultimately responding to the request. There is no requirement as to the qualifications of the person. We strongly advise them to get the necessary training, but it's not required. It could be a file clerk, it could be a school superintendent, it could be a mayor. The law simply says it has to be either an employee or a public official. There also is no language in the law as to how you organize your open records officer. It could be one person overseeing the entire township, or you could split it between the business office and your police department. What really is important is that a citizen, it's clear to them who do they give their open records request to when they are submitting it. So it needs to be clear as to who the open records officer is or who the appropriate open records officer is. An agency or a municipality can come up with its own local rules and regulations as long as they're not in conflict with the law or any rules promulgated by the Office of Open Records. Just a quick example. For instance, the right to know law says that an agency may accept anonymous requests. Well, legally, because that word may is in there, it also means may not. So a local township could pass a regulation that says we will only entertain requests where the individual has identified themselves. You simply need to apply it consistently and equitably. Another example might be the fact that the law says you may accept verbal requests. Well, again, may not. So you could pass a regulation or practice that basically says we will only accept requests that are submitted in writing. The law gives you great discretion with how you administer your program, But like I said, it cannot conflict with the law itself or any regulations that have been promulgated by the Office of Open Records. You can come up with your own right to know form, and many municipalities do. They like to have their seal at the top, perhaps the contact information for their open records officer, maybe cost information, maybe any of those local rules and regulations, so that the public is aware of what the playing field looks like when they enter the realm of the world of open records. Finally, let us know who your open records officers are at the Office of Open Records. We maintain a database that we use periodically to contact all the open records officers. Periodically, we're contacted by citizens who want to know who is the open records officer for a specific municipality. So if you let us know and keep your records up to date, you can do that right online on our website. We'd appreciate it. Now, you're not required to have bulletin boards, but you are required to have postings about the right to know law. Those postings have to have contact information for your open records officer, contact information for the appropriate appeals office. In most instances, that's going to be the Pennsylvania Office of Open Records. Then you have to have a form to file the request. And again, that could be the form that you've come up with, or it could be the state uniform right to know form. And by the way, if someone comes walking in with that form, you must accept it. There's nothing special about it. It's on our website. Many agencies will simply link to that and use that, and that's fine. And then finally, your posting should have any of those local rules or regulations that you have. Also, you're not required to have a website, but if you do, it has to have information on there about the right to know law. My experience is usually on the home page, somewhere down in the lower right or left-hand corner, in very small print, there's right to know law listed, and you link on that or click on that link, and then it takes you to a page with more detailed information. Now, under the right to know law, there are some things that you cannot do. First, you cannot limit the number of requests that any person files within a specified time frame. You can't say, ma'am, I'm sorry, you've already filed 3 requests this week, that's all you get. If she feels compelled to file a dozen requests this week, the law allows her to do that. The other thing that you cannot do is compel a person to tell you why they are filing a right to know request. You cannot deny a request based on the reason or what you think that reason might be. Sometimes the reason is, or the reason appears to be that they're digging up dirt on somebody, whether it be a public official or employee or a neighbor. Sometimes, honestly, we get the impression that people are filing right to know requests simply because they want to see their public employees work harder. That's unfortunate, it happens, but I think overall the effect of this law, the impact has been much more positive than negative. But the takeaway from this slide is that you cannot force a person to tell you why they are filing a right to know request. So let's talk about requests themselves, and in our experience, what is a good request? Well, first seems rather obvious, but it needs to be addressed to the open records officer. And when I use right to know officer and open records officer, those two terms are interchangeable. It doesn't necessarily have to have the open records officer's name, but there should be some indication on there that I want this request to go to the open records officer. If you are a public official, that does make a difference, because if you simply as a matter of day in, day out business, you submit a request to a member of your staff and you don't specify that it's a right to know request, it will be treated just like any other internal transaction within your township. If you do specify that it's a right to know request, then you're treated just like any other citizen, and that request is subject to the deadlines built into the law. But you need to specify that it is a right to know request, and if you're a citizen, make sure that you're addressing it to the open records officer. Yes, sir?
Yeah, are hospitals subject, do they have to have
Okay, the question is, are hospitals subject to the right to know law? Usually not, because they're not considered government entities. However, there may be those exceptions where, given the governance of the hospital or just its organizational status, it may be, but in most circumstances you would not find hospitals subject to the right to know law. You know, the law is, I shouldn't say the law is changing, but the world of right to know is constantly changing. Not that the law has been revised at all, but there is a steady stream of court decisions that impact how we apply the law and how it's interpreted. Jurisdiction is one of those things. You mentioned hospitals. Someone earlier mentioned libraries. You know, libraries need to be decided on a case-by-case basis. Again, dependent on their governance and their relationship to the local municipality. One that we just decided has to deal with state constables. I don't know if any of you are familiar with the world of constables, but it's a pretty unique setup. And finally, after 9 years, the question came up, are state constables subject to the right to know law? And if you look at case law involving constables, it's pretty much all over the map. Our decision was that given what they do, their relationship to the courts, their relationship to the executive branch, or in some cases their lack of relationship to the executive branch, we determined that constables should be held accountable to the right to know law. We anticipate that being appealed to a higher level court in the near future, but that's my point being is that this law is still a moving target driven by new situations that we encounter as well as changes in technology that impact the creation and use of public records.
The reason I ask that is there's a lot of public health issues that hospitals would have information on that certainly might be of interest to the public. I'm wondering if they're just...
Most hospitals, confidentiality issues would be governed by a law called HIPAA, the Health Information Privacy and Portability Act, but they are not subject to right to know as a general rule. Okay, I'm fine with that, and feel free to approach me after the session and I'll answer all your questions. The second aspect of a good request is that it seeks a record. Now this seems rather obvious, but I want to point out the purpose of the right to know law is to give the public access to public records. It is not intended for the public to simply ask questions and then have their government employees, government officials running around researching the answers. So the request should seek a record. Then finally, it should be sufficiently specific. Now this is a term taken right out of the law. Basically it says that any request should be sufficiently specific that someone looking at that request can identify a body of records that are considered responsive. Meaning, when I look at your request, I get an idea of what is the record you're asking for. If I can't do that because you're just asking general questions, then I can deny your request because it's not sufficiently specific. An unusually large number of appeals that our office deals with, this issue is at least part of that appeal, specificity. So I think it's important that you get a grasp of that. This is an important tool for those of you using the right to know law, and it essentially represents the first cut that an agency open records officer will make when considering a request. And they're looking at the request and they're asking the question, are they even asking for a record? And this is the definition of a record taken out of the right to know law. Let me read it real quick. Any information, regardless of its physical form or character, that documents a transaction or activity of the agency and is created, received, etc., etc. I have the key phrase highlighted here. Documents a transaction or activity of the agency. So let me give you an example to help explain what that means. Let's say that I am a township supervisor and I'm sitting at home in my own family room. I'm on my personal computer and I'm on my personal AOL account. And I send a message to one of my colleagues on the board. My daughter has a softball game tonight. I'm going to be about 20 minutes late for the meeting. Now that message is personal. It's what we call a transitory message. And chances are that if a right to know request were received from my emails on a particular topic, that message that I just sent would not be considered responsive because it has really nothing to do with my authority as a township supervisor or commissioner It has nothing to do with business before the board, and really it has no impact on the public that we serve. So that message would not be considered responsive because it doesn't rise to the definition of a record in the right to know law. Now let me change the example up a little bit. I'm that same township commissioner. I'm in my same family room, same computer, same personal account. But this time I send a message to my colleagues on the board. I understand at tomorrow night's meeting this proposal is coming up to revise an ordinance. I have some concerns about that. Here they are. And you know, at this point, I'm leaning against voting for the proposal. But first, why don't you tell me what you think? Now, number one, I've just violated the Pennsylvania Sunshine Act big time. They're shaking their heads back there because I'm deliberating outside of the public eye. But for purposes of this example, I think you can see the distinction between the first scenario, where I'm simply late for a meeting, and the second scenario, where I am exercising my authority as a public official. I am discussing a matter that will ultimately be before the board, and it will have an impact on the public that we serve. So in the second example, the message clearly does rise to the level of a record, or the definition of a record, under the right to know law, because it does represent and document a transaction or activity of the agency. So all day long, we are generating messages that don't rise to the definition of a record. And we don't have to worry about messages like that ending up on the local news site or ending up on the front page of the paper tomorrow morning. Hey, let's meet for lunch, or I'm picking up a pizza on the way home. All day long, we generate messages like that that are not considered records, and therefore we do not have to worry about them being included in the response to a right to know request. So like I said, this is an important tool because it is the first cut that an agency open records officer will make in eliminating a large percentage of messages that we generate day in and day out from the world of right to know. If you remember, the other factor of a good request is it's sufficiently specific. Last year there was a court decision coming out of the Commonwealth Court of Pennsylvania where Justice Brobson provided some very useful language on this issue of specificity. The first is that a request should identify a subject. Essentially, a person cannot come walking into your offices and say, I want to see everything that's in that file cabinet. No, they at least have to say, I want to see everything that's in that file cabinet concerning, and then identify a subject. Then they have to identify a scope. And when I say scope, I mean a discrete group of records, all these emails, all these reports, all these memos, all these text messages and the like. Okay, they simply can't say, well, I'll tell you up front, whenever we see the term any and all, it raises a red flag because it creates the impression that perhaps the request is not specific enough. And then finally, there needs to be a time frame. And sometimes it doesn't need to be implicit, or it doesn't need to be specific. It can be implied. Ideally, it would be a date, you know, from and to. Or perhaps it's an email or emails from a person to another person. But as far as a date being implied or time frame being implied, it could be, I want to see all of George's emails, and George started 3 months ago. So it's implied that the request would include emails from 3 months ago to present. But most likely, when it comes to time frame, it cannot be open-ended. You cannot ask for everything that ever was ever generated into, you know, the far distant past. Likewise, you cannot request records that have yet to be created. You can't submit a right to know request that says, please send me the meeting minutes from now on every month after your meeting. An agency is only required in most cases to provide those records that it has in its possession. And if a record has yet to be created, obviously you don't have it in your possession, therefore you would deny that request. So, an agency receives a right to know request. Let's walk through what needs to happen. It should go immediately to the agency open records officer, who should note the date that they receive the request, because there are hard deadlines built into this law, very date driven. So if a request were received today, tomorrow would be considered the first business day. And we should emphasize, and I don't think it's that important here, but maybe people listening may be impacted by this, that it's your business days. So that if you're closed for a holiday, that's not a business day. If, say, you're a school district and it's the summer break and the administrative office is only open 3 days a week, well, then your 5 days would be hypothetically Monday, Tuesday, Wednesday. Then the second week, Monday, Tuesday. You might think this is kind of unusual to emphasize this, but there are municipalities in the Commonwealth that are only open 1 day a week. And their 5 business days amount to 5 weeks that they're required to provide an initial response. Maintain a copy of the request until it's fulfilled. Actually, my recommendation is to maintain a copy of the request for at least 30 calendar days, even if you think you are granting the request. Because what may happen is a person would get home, look at the records you've provided, and they're not satisfied. Perhaps you've redacted information that they were hoping to see. So they may turn around without contacting you and file an appeal with our office. Well, after 30 days, if you haven't been notified of an appeal, either you're not going to be, or if the person still attempts to file an appeal, most likely it will be dismissed as untimely. So while there are retention schedules out there that recommend holding on to your right to know paperwork for various time frames, I think once you've reached 30 days, you're pretty safe legally as to whether you still need that or not. Now, if you're unable to provide the response or the records within the initial 5 business day window, the law allows you to unilaterally invoke a 30 calendar day extension. But in order for that extension to be valid, you need to do it the right way. First is that you must invoke the extension within the initial 5 business day window. You can't wait until the 6th day, suddenly realize, oh my gosh, I forgot about this right to know request. Well, we'll take the extension. No, unfortunately, legally, you've already deemed denied the request through your failure to provide an initial response during the 5 business day window. Then you need to notify the requester in writing that you're taking the extension. And remember, it's unilateral. You do not need the requester's permission to take the extension. You simply need to notify them. You need to provide a reason why you're taking the extension. And fortunately, Section 902 of the law actually lists 7 reasons that you can take. One may be that we keep these records off-site, and it's going to take us longer than 5 days to go find them and sort through them. Or perhaps we want our solicitor to review the response to make sure we don't give out anything we're not supposed to. And it's going to take our solicitor longer than 5 days to review the package. There's one that simply says, given the nature of the request, we're going to need more than 5 days. So it could be unusually large or complex. But I would ask and caution you not to get into the habit of automatically invoking the 30 calendar day extension whenever you receive a right to know request. If you're able to provide the records within the 5 business day windows, it's what the public expects. And if they're of the impression that you can do it in 5 days, but yet you automatically invoke the 30 calendar day extension, they're going to be rather dissatisfied about that. And we receive a fair amount of complaints, wondering if there's any recourse for them when they believe an agency is arbitrarily invoking the 30 calendar day extension. Then you provide a date as to when the requester can expect to receive their records. Usually it's the 30th day of the extension, and the very last possible date. Then you need to provide an estimate of any costs that the requester can expect to incur as a result of you preparing the response. It is just an estimate. You're not providing a hard quote. So if it's a little high, a little low, that's fine. You simply settle up when it comes time for the actual exchange of records for payment. So you've got the 5 business days followed by the 30 calendar days, essentially what we call a 35-day window. Now, within the right to know law, there are exemptions, 30 of them, that essentially define bodies of records that allow you the discretion to withhold from public disclosure. This is the Open Records Officer's second cut. They've made the first cut where they've asked the question, is it a record? Now they're asking, is it a public record? Essentially, and if you were to look at the right to know law, I have a copy up here on the table. It's not a big law. It's written in reasonably plain English, so it's not hard to understand. But if you were to look at section 708B, which includes all of the exceptions, each one of these has a couple paragraphs defining it. And if you were to look through these slides, and all 30 of them, you would see that it pretty much makes common sense that when you look at the exemptions and the types of records that are included, you most likely would not expect these to be public. We talk about any record that if I were to give it out, it would perhaps risk someone's personal security, or employee records that might reflect performance issues or discipline issues. Personal identification information when you have a concern about identity theft. Like I said, all of these pretty much make common sense. And all of these have been litigated, meaning that you will find either a ruling from our office regarding every one of these exemptions, or a good chance that you would find court decisions that cover these as well. I should mention that the main product of our office is what's called a final determination. It is a written ruling that carries the weight of law, that if you were to see one, it looks just like what you would see coming out of your Court of Common Pleas. And you could take one of these decisions in response to an appeal before a judge and say, this is what the Office of Open Records have ruled, and they would need to enter it into the record of whatever case they have at hand. Since 2009, at roughly $2,500 a year, we're upwards of 19,000 final determinations that are all in a searchable database on our website. So you can go to our database, you can search by exemption, you can search by municipality, you can simply put in a string of words to see how we've ruled on a particular issue, and it will pull up all of the responsive cases. If your solicitor, or if you have access to one of the legal services like Lexis or Westlaw, all of our decisions are out there. As a matter of fact, if you have one of our docket numbers, you can usually Google it and the case will come up on the internet. So there's a lot of good decisions out there for some reading if you're interested in how our office or how the courts have ruled on a particular issue related to open records. Again, all of these exemptions cover a broad range of records. So this being the second cut, number one, you've eliminated a large percentage of messages that you generate day in and day out by simply answering the question, is it a record? Now, any that have made it through that cut, you're eliminating a tremendous amount of records that may fall in one of these exemptions. And you can see by looking at them that it covers an incredibly broad spectrum of records, all of which, like I said, you would not expect to be available to the public. So after this second cut, and again, these are discretionary, which I'll talk about here in a moment. If the record has made it through the second cut, then essentially what you're saying is that it is a public record and should therefore be released. Now, here is a very important concept, and this is really misunderstood by a lot of people, especially on the municipality side, when it comes to dealing with the right to know law. And it's the fact that the right to know law is not a confidentiality law. There is nothing in the right to know law that mandates the withholding of records. And there is nothing in the right to know law that says you must use the right to know law in order to give out public records. I, as a citizen, can come walking into your offices and say, I'd like a copy of the budget. And you may very well have a stack of budgets sitting there. There's absolutely nothing preventing you from simply reaching over and handing me a copy of the budget. The right to know law does not prevent you from doing that. I'm going to, we have some interference here, and I'm wondering if it's my cell phone somehow. Let me try that. I think that's what it was. Okay, so to get back on point here, there is nothing in the right to know law that says you must use the right to know law in order to give out public records. You can simply give them out if you choose to. The law allows you that discretion. As a matter of fact, if I come walking into your offices and I do have a right to know request and it's for a copy of the budget and you've got a stack of budgets sitting there, you can say, George, you know what? It would save me a lot of paperwork and it would save you a lot of time if you'd simply tear that right to know request up and I'll give you a copy of the budget. You can do that. You're not violating the right to know law. I'm getting what I'm asking for, and you're saving yourself a lot of paperwork. And no one at the Office of Open Records takes it personally if that's what you do. However, if I say, no, I want to follow the process, I want this to be a right to know request, well, then you have to follow it. And all the associated deadlines, all of the responses and the like. I don't know why I do that, because I may very well end up waiting 35 days for that budget that's sitting right there. But if I say I'm going to follow the process or I want the process to be followed, then you're compelled to do so. The other thing is that, like I mentioned, all of those exemptions, the 30 exemptions within the law, essentially are discretionary. So that if you have a record in your possession that clearly falls within one of the definitions of one of those exemptions, you can still release the record. And it does happen. I'll give you a good example where one of the exemptions is 708B18, which basically says that a 911 center can withhold any record reflecting a recording of a phone call or a radio transmission regarding emergency services. But yet we have all heard those phone calls in the media, whether it be someone calling in a crime or a fire or disaster of some sort. In that particular instance, the County Emergency Management Administrator has used his discretion where he's decided it's in the public interest to go ahead and release that recording. Perhaps it will help solve a crime, perhaps it will help prevent crimes, maybe it's just an interesting human interest story. And despite the fact that probably one of the tightest written exemptions within the law is 708B18, we hear these recordings all the time of people calling in to a 911 center. It's where, again, where the agency head has exercised their discretion because the right to know law allows them to do that. So essentially, if you've determined that it is a public record and the exemption doesn't apply or you've chosen not to invoke an exemption, you can release the record unless it is covered by another law that deems it confidential. If that's the case, then the other law is controlling. The other law trumps the right to know law. For instance, law enforcement, most of their records are dictated by a law called CREA, the Criminal History Records Information Act. CREA essentially very broadly defines groups of records that law enforcement typically touches, and it mandates that those records can only be released to another law enforcement agency. They cannot be released outside of that universe. So, in order to respond to a right to know request, the law enforcement might deny the request not based on an exemption within the right to know law, but rather based on the appropriate provisions within CREA. And for instance, criminal intelligence information that's gathered on criminal activity, not covered by the right to know law. However, it is clearly covered by CREA. Typically, the Pennsylvania State Police will invoke CREA on records that are requested from them, and that is their legal basis for denying access to the records that have been requested. If anyone here or anyone listening has a child in college, they've probably gone through the exercise of wanting to see their grades. And as it turns out, it's not as black and white as one would think. Rather, the student needs to sign a waiver and give it to the university that then gives the parent permission to access the student's grades, even though the student or the education is clearly being paid for by the parent. So it's kind of ironic. That law is called FERPA, the Family Educational Rights and Privacy Act. School districts will commonly run up against this law, where someone has requested the grades given out in a specific class because maybe they suspect that their child is being graded unfairly. Well, FERPA basically makes it illegal to give out individual educational records. So the school district would invoke FERPA as the legal basis for denying access to the records. And remember at the beginning when I was describing this law that it is the municipality, and that would include school districts, it's the municipality's burden to show legally why the record should not be released into the public domain. So if you're using a law like CREA, FERPA, perhaps HIPAA, the Health Information Privacy and Portability Act, which makes it illegal to give out personal health information, that would be controlling, and it would trump any discretion that the right to know law would provide. Another aspect of confidentiality is what we call privilege. Typically, this is attorney-client privilege, where you have a board receiving advice of a solicitor. Well, any communication between the solicitor and the board regarding legal issues would be protected by this concept called privilege. And any record generated, whether it be an email, memo, report, or whatever, would not be released into the public domain because privilege would prevent it. That could include invoices. It just depends on the level of detail that the solicitor goes into. If the invoice is simply a list of charges, then chances are it's not protected by privilege. If, however, it goes into such detail that it may reveal a legal strategy, then privilege would apply. And I should mention that other than the Supreme Court of Pennsylvania, the Office of Open Records is the only other legal entity in Pennsylvania that can rule on whether privilege applies or not. So essentially, the open records officer is asking that question, is it a public record? If they're invoking one of the exemptions, or if another law deems that record to be confidential, or if that record's protected by privilege, essentially they're saying it's a record, but it's not a public record. If, however, the message makes it through, then you're saying it's a public record and it should be released into the public domain. So I think you get an idea here of the power of the tools available to agencies and to exercise their discretion with withholding records if they feel they have a sound business case for doing so. Now, let's say that you've gone through this exercise and you've determined that you do in fact have a sound business case for denying access to a record, not releasing it to the public in response to a request. Well, you have to issue a written denial, and there's a right way to do it. So let's talk about how that occurs. It's a denial letter. You've reduced it to writing. And essentially, the first thing you need to do is describe the records in question. This seems kind of obvious, but sometimes it's not always black and white. I'm not a lawyer, but I play one on TV, so I write out a request that's somewhat verbose and hard to understand. It may not be clear to everyone what exactly I'm asking for. So by describing the records in question in your response, you're more or less framing the issue. Also, if the matter ends up being appealed, you're clarifying it for any subsequent appeals officer or judge. This is what we think the requester is asking for and why we're subsequently going to deny these records. The next thing you need to do is state your legal and factual grounds for the denial. Remember at the beginning, what's different about this law is that now the agency, the municipality, bears the burden of proving why the record should not be released into the public domain. This is where the rubber hits the road. This is where the agency is presenting, essentially in shorthand, their legal case as to why they believe the records are not public. Usually they are citing one of those 30 exemptions within the right to know law. But again, like I said, if there is another law that makes these records confidential, they may cite them as well, or other than. Then you have the name, title, and contact information for the agency open records officer. Remember, the agency open records officer is the person legally responsible for responding to the request. So their name goes on the denial letter. Also, if the request does get appealed, then it's the agency open records officer who ends up being the contact person from the Office of Open Records to notify them that in fact we have an active appeal. Finally, or I should say next would be the date of the response. This is important because I talk about the hard deadlines built into this law. Well, when you date your denial letter, another window kicks in, and it's the appeal window, which we'll talk about here in a couple minutes. And then finally, in your denial letter, you need to tell the person that if they disagree, they have appeal rights and what those appeal rights are. And usually it involves getting in contact with the Office of Open Records. I want to spend a little bit of time talking about payment issues. If you're having difficulty with a requester who perhaps you feel they are submitting requests that are frivolous or burdensome in some way, and if you're a member of the public sitting here, hopefully you're not that type of person, but I think you know how you could use this law to really overburden a municipality given the prohibitions that are in it. I'm going to put this out there to everyone to make it clear that oftentimes you can address those problems through the payment process, because there's a lot of misunderstanding as to what you can charge and what your obligations are relative to the right to know law. The first one is probably the most important, and it has to deal with the fact that a municipality is only responsible for providing the records in the medium in which they exist. What does that mean? Well, essentially it's hard copy versus electronic records. So that if I were a requester and I submitted a request and I want the records sent to me electronically, I want them emailed to me because it's convenient. But let's say that the township doesn't have them electronically. They only have them in hard copy form. The township is not obligated to scan in those records to send them to me electronically. They do not have to convert a record from one medium to another in order to respond to my request, so they can deny it. Conversely, if I submit a request for a record, let's say it's an email, but I want those emails sent to me by hard copy. I want them printed out so that I can see the metadata that's on them. Maybe I'm concerned about how they were generated or the times that they were sent or received or so forth. And that information is only available when you print out that specific type of email. Well, if the records only exist on an email server and they have not already been printed out, the municipality is not obligated to print out an electronic message and send me the printed copy, because that would be converting the message from electronic medium to hard copy medium. Now, at your discretion, if you want to scan in a hard copy record and send it to me electronically, you can do that, but you cannot charge for electronic records. There is an exception, of course, and that's where you may have to redact information that, and in this particular case, it would be an electronic record originally. Let me just cover this real quick. Let's say I submit a request for emails and I want them sent to me electronically. However, in those emails, there's some sensitive information. It could be a personal email address. It could be a home phone number or a social security number. Well, in order for the municipality, the township, to send me that email, they first have to redact that sensitive information. They do that by printing it out, getting out their black marker, crossing out the sensitive information, scanning it back in, and then emailing it to me. Well, you can charge for that piece of paper that you had to generate in order to redact the information. So while there is no charge for electronic records, that's a common exception that often comes into play. Just let people know ahead of time that they should expect some sort of cost relative to electronic records, even though they're expecting them for free. But because of redaction, there may be a minimal charge. The other thing is that at your discretion, if you want to print out a record because I've requested it hard copy and send it to me, you can do that. But then you can charge for those hard copy records. And you would follow the fee schedule that the law allows the Office of Open Records to establish. Again, it's on our website. Basically, it's 25 cents a page, 8.5 by 11, single-sided, black and white. I think it's 35 cents for color copies right now. If someone asks to inspect records, if you're familiar with the right to know form at all, it gives you two choices. One is to receive copies. The other is simply, I want to inspect the records. I want to come into the office and just look at the file. All right? So if someone requests to inspect records and the agency is in the driver's seat, they establish the date and time during normal business hours when it is convenient to have someone come in and look at the records that they've prepared for inspection and a reasonable amount of time to do so. Well, let's say that that's occurred, so I'm sitting at a table in an office somewhere. Maybe I'm being supervised to make sure I don't put any records in my pocket or anything. And again, you can do that. But let's say I pull out my cell phone camera and take a picture of a record. I'm allowed to do that. The law allows me to even bring a copying machine into your office to make copies, as long as I'm not disruptive to your office operations. Okay, if my scanner is in the way, if it's making a lot of noise, if it's in any way disruptive, you can shut me down and say, look, this is unreasonable. You're going to have to wrap things up. If I bring my kids along and my kids aren't the best behaved, maybe they're impatient with having to wait around while I inspect records, and they're causing a disruption. The agency, the municipality, is in the driver's seat. They can shut down the inspection session because of the disruption. Just be, reasonable in any rules that you apply, and apply them equitably, and you should be fine with that. You can't charge for labor. You can't charge for the actual act of redaction. And you cannot charge for any legal review that you feel your solicitor has to make before releasing any records. The municipality has to more or less eat those costs. You can charge for what we call actual costs or pass-through costs. For instance, if I submitted a right to know request for a copy of one of those maps, and let's say it's determined that that map is a public record, well, you may not have a large-scale copier. So you would have to run down to Staples or Kinko's or perhaps the local engineering firm, and they would run off a copy for you of that large print and maybe charge you $18 a sheet. Well, you can pass that $18 on to the requester as an actual cost. Another example would be postage. Let's say that you've received a right to know request, you've assembled your response, It's, you know, a couple inches worth of paperwork. You put it on the meter and it comes out to $3.15. Well, you can add that $3.15 onto the invoice that you would send to the requester as payment for the records that you've generated. Now, more payment issues, you know, I think I've kind of alluded to this, but let's just get it right out there. It's best that there be no surprises. Worst case scenario is that you receive a right to know request. The township spends several hours assembling the records, maybe quite a bit of effort copying those records. They prepare the response and notify the requester, hey, your response is ready to be picked up. They come in all smiles. You push the records across the counter and let them know, okay, it's going to be $30. But they weren't expecting any charges. You know, they thought, well, this is right to know. I thought this was free. And then you show them the invoice, how you calculated it, and they say, but wait a minute, these are public records. Don't my tax dollars already pay for these? And you can see where this conversation is headed. So they get in a big huff after, you know, some colorful words and walk out without their records and without paying you. Now it's only $30, but think about the hours of time that you put into this project, and they're wasted. You now have nothing to show for them because you didn't let the person know to expect a certain amount of charges. So when you receive a request on the agency side, do a quick estimate. You know, take a look at these reports. I've got this, this file here. Okay, I think it's going to run about $30. Pick up the phone or send an email back to the requester saying, we estimate it's going to run about $30. Are you okay with that? There's absolutely nothing wrong with doing that. Their response is either going to be, whoa, hold the phone. I didn't realize there was a charge. I'm withdrawing my request. Or they're probably going to say, well, okay, yeah, I'll pay that. So then you proceed before you invest a lot of your time and effort into responding to the request. Communication is good, and there's nothing wrong with communication between a requester and an agency to make sure that the public is getting exactly what they're asking for when they submit a right to know request. Now, ideally, it would be a mutual exchange, meaning they come in with their check, I've got the records, and you know, you switch. However, the way the law is written, it says that records are provided upon payment. So that if push comes to shove, the requester pays first, and then they get the records. And the law is silent on how you develop your invoicing system or whatever. So again, as long as it's consistent with the spirit of the law, you should be fine. But you know, basically the law says you pay first, then you get the records. And if it appears that the response, that the cost of the response is going to exceed $100, you can ask for all of the money up front before you begin processing the request. So that if you have a substantial response, before you invest that time, you can tell the person, we need full payment, or at least, you know, an estimate of what we consider the full payment to be before we begin processing the response. Now, if you've made arrangements for the person to come into the offices to pick up their response, the law allows you 60 days in which you have to hold on to that response. If you get to the 61st day and the person has not come in to pick up the documents, you can throw them out. You can discard them. You can shred them. You can do whatever you need to do. Because essentially, you've met your obligations. The law says 60 days. So the 61st day comes around, you can, you know, get them off your desk, get them out of your hair. Now, if on the 62nd day, the person comes walking in to pick up their records, well, they are out of luck. And they're out of luck on several different levels. First, let's say that that response costs $30. They still owe you that $30 because you did everything you were supposed to. The agency did everything they were supposed to. You know, they prepared the records, they granted the request, and everything was there ready to be picked up. It's not the agency's fault that the requester didn't show up within the 60-day time frame. And if the requester still wants the records, they have to file a second right-to-know request. And it's probably going to cost another $30. So there's a second $30. But the agency doesn't even have to begin processing the second request until the first one, the initial request, is paid for. You can deny access to a subsequent request if there's a non-payment issue for an initial request. Even if that person wants an entirely different set of records, not related to the first request, that rule still applies. You do not, the municipality does not have to process any further requests until the account is settled up and no longer in arrears. Oftentimes when you are dealing with challenging requesters, it's the payment issues that provide the solution, because invariably there's a non-payment issue. And when someone, usually when an open records officer calls our office, you can tell they're frustrated. Sometimes they're reduced to tears because of how someone has treated them with burdensome requests. This is the solution. It usually is somewhere in a payment issue. If you are denying a request based on non-payment, I suggest that the township have its paperwork in order. Make sure everything has been documented as to what's transpired between the requester and the township related to this issue of non-payment. Because if you've denied the request, it can be appealed. However, if we receive an appeal where non-payment is the issue, and you have your paperwork in order, most likely an appeals officer is going to agree with the township or the municipality. But you need to have your paperwork in order that documents any transactions that have taken place up to that point. Now, if you've issued a denial, like I've said, the requester has the right to appeal your denial. Typically, they have 15 business days from the date of the denial, or when they should have expected to receive the denial, to file an appeal, usually with the Pennsylvania Office of Open Records. And it's 15 of our business days, the Office of Open Records. Now, we're an independent entity, but we follow the state's holiday calendar. And there may be some holidays where the state is open, but local government is closed, or vice versa, like election days. Or there may be a snow emergency that closes, one office but not the other. This is important because it's surprising how many people wait until the very last minute to file an appeal. And it's sad, but a fair percentage of appeals get dismissed as untimely because somebody miscalculated the calendar or whatever. But it's 15 of our business days in which they can file an appeal with our office. Those appeals can be filed online. Most of them are. Again, on this wonderful website I keep talking about. It usually takes about 20 minutes, and requesters don't need to be an attorney in order to file an appeal. The first thing we do when we receive an appeal is make sure it's complete. And there are 4 elements that we look for. The first is we need a copy of the original request. What were you asking for in the first place? Then we need a copy of the agency's response, provided one was given. Okay, that needs to be included. Then the requester needs to tell us why they think the records that they're asking for are public. And finally, the requester needs to tell us why they think the agency's response is wrong. So you can see, ever so slightly, the burden is shifting a little bit to the requester. Now they need to, do a little bit of homework to tell us why they think the record should be public. So if these 4 elements aren't present, we will issue what's called a deficiency order, where we give the requester 2 days to correct the deficiency. If they fail to do that, the case gets dismissed as insufficient, and it gets kicked out. However, if all 4 elements are present, then the case gets docketed. And essentially what that means is it gets assigned a number, AP 2018, and then usually followed by a 4-digit code. It gets assigned to an appeals officer, who we have a staff of 19 currently. Given those 2,500 final determinations a year, you can get an idea on the workload that we have. But it gets assigned to an appeals officer, and then we send out notification to all of the parties that the Office of Open Records has this active appeal. Now, if you're on the agency side, municipality, and you receive notification of an active appeal from our office, the best advice I can give you is immediately, without delay, contact your solicitor. Everything I've talked about up to this point, I'll describe as an administrative process. The right to know request, the agency's response, and so forth. Once an appeal is filed, there's a term that the Supreme Court has used to define us. It's an independent quasi-judicial tribunal. Now, we're still trying to figure out exactly what that means. But for your purposes, essentially, we are a court. And when that appeal gets filed, the court kicks into session. And while at the request phase, you can do things a certain way. You can reply to a right to know request on a sticky note if you want to. At the appeal phase, you can't do that. For instance, let's say someone asks for a record that you don't have. At the request phase, you can simply write them back and say, we don't have this record. At the appeal phase, a statement like that would need to be supported with an affidavit or an attestation, where essentially it would say, I, Jane Doe, am the open records officer for Radnor Township. I have conducted a good faith search for these records, and I am the person responsible for these records, and I have determined we're not in possession of the records that have been requested. I sign this under penalty of perjury, and I sign my name and date. That is sufficient to be entered into the record of a right to know appeal. And so the higher courts require us to respond to them following appropriate format and procedure. So we need at this point to require it of you. And therefore, on the agency side, because you bear the burden, that level the bar is somewhat high. And your solicitor will know how to respond appropriately. It doesn't happen nearly as much as it used to, but an inordinate number of cases would be decided on procedural error and never giving us a chance to really deal with the merits. So that's why, again, it's important that you contact your solicitor immediately. We receive notification of a right to know appeal, and essentially now they've got some new, very tight deadlines that your solicitor has to work with. Chances are the agency staff, the municipal staff, will be the boots on the ground, looking up documents, providing statements and the like, but your attorney, your solicitor, will be the point person. Now, as I indicated earlier, the product of an appeal is what's called a final determination. We have 30 days in which to provide a written decision. Basically, the way it works is when this notification is sent out, there's a 7-day window that the parties can enter documentation and statements into the record. That window closes, and then there's another 21 days that the appeals officer would be looking at what's entered into the record. They'd be looking at the right to know law. They'd be looking at appropriate court decisions, maybe other laws that would provide guidance. And they take all this information together and write the decision. And it goes through a rather robust editing process. And then we issue those decisions. Occasionally, we may ask for a 30-day extension. This doesn't happen often, but if a case is complex or there may be some extenuating circumstances, I would ask that you grant our request for an extension. These are legally binding final orders, meaning they carry the weight of law. And like I said earlier, They're available on the various legal services. Our decisions can be appealed to higher level courts. So Radnor Township would, if we would issue a ruling that either you or maybe the requester disagrees with, they would have 30 days in which to file with the County Court of Common Pleas. We're not a party to the dispute. We're basically that lower level court that I talked about, but you have to notify us that you are taking the case further. And we'll do one of three things. We may simply monitor the case through appropriate legal channels to find out, exactly what's happening. We may submit briefs for a number of reasons. One may be to simply explain to the judge, this is why we ruled the way we did on this particular case. Oftentimes we've found that at the county level, you can't expect a common pleas judge to be up on all the nuances of the right to know law. It's not something they run across day in and day out. So it may simply be providing them with documentation to educate them on this is how you interpret the right to know law, apply various principles and why we rule the way we do. Or we may in fact ask to participate in the litigation. And for instance, if you're familiar with PCN, the public cable network, you get up in the middle of the night, you can't sleep, you're flipping channels, and there they are. Attorneys standing before the dais of the Pennsylvania Supreme Court. The chances are reasonably good that they're arguing a right to know case. So, watch that for a couple minutes and it'll put you right back to sleep. But no, I'm being sarcastic. But we do have litigators on our staff, and it's not unusual for us to participate in court arguments. Yes?
Before you go on to the next topic, could we ask the question about
Yeah, this is probably a good time. Let's spend a little bit of time asking questions before we jump into the Sunshine Act.
format for them? Great, thanks.
Okay, are we taking questions now, or are we going to wait?
Getting a microphone.
Oh, okay, great. Why don't you go ahead and say the question and I'll repeat it.
Okay, so I actually have two questions, but I'll ask one and then
Okay,
it's my turn.
go ahead.
I know that agencies. Thank you. Responding to a right to know request, but they are allowed to charge for the per page,
Right, basically, they're paying for
Right.
the toner and the ink.
Correct. So has the Office of Open Records weighed in or opined in this era of being able to create electronic records? So many of the records that might be requested in a right to know request are actually likely emails or
Yes.
other documents that could be captured as a PDF or could be captured electronically. Does the right to know, does the Open Records Office, require that they be given to the requester in paper format such that there is the paper charge, or is there an option to give it to, or let me ask it a different way, does the requester have the option to request for it electronically so that they don't have to pay the paper and toner charge?
Well, the ball is actually in the municipality's court. They have the discretion in how they want to give you the record. If it's in electronic format, then that's how they have to provide it to the requester. However, if you've requested the record in electronic medium, but it's not in electronic medium, then it's the municipality that has the discretion to scan it in or not. Basically, they don't have to. The law says they don't have to, but they still can if they want to.
So if the format of something is in electronic format and it's and it's granted,
Yes.
and it's a 10-page document in electronic format,
If you
there's a
request
per
it
charge
electronically,
payment.
then that's how they get it, and no, they cannot charge you for electronic records unless they need to redact.
Take the time to redact
Information.
information. Okay.
Yeah.
All right. I'm happy to turn this over to somebody else, but I do have one other question. Here you go. Oh, all right. Well, so the other question is, I attend meetings and I'm an elected official, so I've heard this statement used. a member of the public wants information, and for whatever reason, it's not being provided to them, at a meeting, and the member of the public will say, well, we're entitled to that under the right to know law, as if because they say it's just, it is one of the, everything is presumed to be open unless it's an exemption. They will use the term, well, we're entitled to that because of the right to know law, but that sentence doesn't mean we have to just tell somebody something right then and there. If they want to pursue that comment.
Is there a question coming?
So the question is it accurate that simply coming to a meeting and saying that is enough to have the agency have to answer the question that's before them?
Well, in general, no. First, I think we've mapped out a process that typically one would need to follow in order to appropriately submit a right-to-know request. In that particular instance, it could be implied that the person is making a verbal right-to-know request, which is a very good reason why an agency should pass a rule saying we'll only accept them in writing. However, simply standing up and demanding to see a record probably wouldn't pass muster. We haven't dealt with specificity and all those aspects of it. And just standing up, I'm not even talking to the open records officer, I'm just shouting at the public officials. So, yeah.
Okay. Appreciate that.
Yes, sir.
Yeah. If you're requesting records that are on a database, and it requires searching and selecting information out, which is a result that can be gotten, but may not be a pre-existing form. It takes some search and selection.
Let me say a couple things, and maybe it'll address where we're headed here. Number one, you're not required to create a record in order to respond to a right-to-know request. It's only for existing records in the majority of cases. Number two, you're not required to conduct research, meaning if the records are not readily apparent. For instance, if I submit a right-to-know request that says, I want to see all of the board minutes where this particular subject was brought up, and we maintain our minutes in hard copy form. So in order to respond, I'd have to go through all the minutes to discern. That's research, and I'm not required to do that. Now, regarding databases, that can be a little tricky because of the electronic nature of records and the power that we have to search. I could submit a right-to-know request that says I'd like to see all emails based on a keyword. And if that keyword is specific enough, then it's a valid request as far as the courts are concerned. Or I may ask you to generate a spreadsheet, which essentially you could view that as creating a record, but there's actually a court decision out there, Gingrich versus the Game Commission, where the court said, look, the Game Commission has this information in a database. The database is the record. The spreadsheet that we're requiring you to create is simply a report of that record. So I think that's the one extreme. But as far as needing to go through and actually conduct research in order to generate a record to respond to a right-to-know request, that's the other extreme, and you don't need to do that.
That answers my question.
Great.
Thank you.
Great. One more question before we move on to the Sunshine Act.
Hi, thank you. It's loud, sorry.
That's all right.
I don't know if you've come across this or if this falls into open.
We've seen it all.
Okay, so personal emails or text messages.
Yes.
Does that fall into it? If you say I would like
Yes, it's
records
a very good
in
question.
this-
First off, Ann, if you remember the example when I was talking about a record, I was at home. I was on my personal computer on my personal AOL account. I just gave away my age because I still use AOL. But
I do too.
you cannot expect to use private equipment and private accounts to hide the public's business. It's the content of the message, not where it was sent from or how it was sent or where the message is being retained. So that if I'm a public official or a public employee using my personal phone or my personal account, but I'm conducting township business, it nevertheless is considered a public record and should be disclosed.
And so is it your township's person in charge of the open records? It's their job to then seek out that information from the officials?
Yes. Let's be realistic, though. As an open records officer, I'm not going to go to a township commissioner and say, I need to see your home computer to pull out any township business emails. Rather, what you would typically do is let everyone know, or let the appropriate parties know, we've received a right to know request. It's asking for emails. If you have any responsive records on either your township account or a personal account that are applicable to this request, please provide them to me. And you're relying on good faith. Now that's at the request phase. At the appeal phase, then we start talking about those attestations, and the public officials might very well have to provide an attestation saying, I have given all responsive emails, both from my personal account and my township account, that are responsive to this particular record or request. Yeah, as far as text messages go, it's going to depend. Well, the same standard applies. But there, the obligation of the municipality, and recognizing that now you're dealing with a private carrier. So if it's not on your phone, where you can usually print out a screenshot, let's say you deleted it, the township's obligation is basically to go to the carrier and say, can you provide these text messages? Usually that answer is no. Well, you've conducted your good faith search. You do not have to bring in outside forensic experts to retrieve otherwise deleted messages that you may have deleted from a server or whatever. If you have the internal resources and the internal staff that can retrieve, let's say I deleted an email from my laptop, but it's still on the township's email server, and we have IT staff that can retrieve them off the email server, then you do that. But you do not have to bring in outside expertise that you would pay extra for in order to do that, either with emails, text messages, or phone records. Okay? All right, good questions. Let's go ahead and move into the Sunshine Act. And I want to distinguish, the right to know law is intended to give the public access to public records. Now, the Sunshine Act is intended to give the public access to open meetings. So we're going to spend a little bit of time talking about that aspect of government transparency. First, let's talk about who is covered. Well, any state or local government body, obviously, but also all committees. And when I say all committees, it doesn't really mean all committees, but I'll say most committees. And there's not full agreement on this aspect of the Sunshine Act. But I'll give you my reasoning. The Sunshine Act basically says that it includes that term committees. However, one, the committee must be performing an essential government function. Meaning if there's a committee appointed to review all ordinances to make sure they're up to date, okay, that is a pretty important role, a pretty important task, and I think we could agree that that's an essential government function. However, if I appoint a committee, or if the board appoints a committee to oversee the organization of a parade honoring the local girls softball team who made it to states, all right? Not necessarily an essential government function. So I'm not sure I would say that that committee, the second one, would be fall under the umbrella of the Sunshine Act. The next aspect is that the committee needs to be exercising authority to take official action. Now, you might be thinking, well, the committee doesn't take official action. Only the board takes official action. However, in the Sunshine Act, making recommendations is defined as official action. So I think there's the rub, and that's the crux of the issue as to whether a committee falls under the requirements of the Sunshine Act. Are they making
recommendations that rise to the level of official action. So that if that committee that's assigned to review all the ordinances and make sure they're updated reports back to the board that ends up taking subsequent action, chances are that that committee would be subject to the Sunshine Act. But, you know, full disclosure, there's not, number one, there's not a lot of case law available on the Sunshine Act. And number two, you're going to find a lot of people that argue against this, that say the full board is where the rubber hits the road. They have the authority, therefore committees aren't subject to sunshine. But I'm just taking what the law actually says. And it's a literal application of the language of the law. And my opinion is that when in doubt, you want to sunshine your committees so that you're not in potential violation. Now, a big aspect of the Sunshine Act is public notice, letting the public know ahead of time that you're having a public meeting. Typically, at the beginning of the calendar year, you have an organizational meeting. 3 days before that meeting, at least 3 days before that meeting, you have to provide notice in a newspaper of general circulation of the date of that organizational meeting and then all subsequent meetings throughout the calendar year. You know, whether it's something like the second Thursday of the month, you know, this particular board will be meeting, then you've met your obligation. And it needs to be posted at the meeting site, you know, the schedule of meetings. I know that there's a lot of concern over the fact that newspapers are disappearing, and it's becoming more and more difficult to advertise meeting notices in newspapers. It's come up several times before the legislature to try and get them to open this up to websites. Unfortunately, we've yet to see that. So as it stands, the notices need to be printed in a newspaper of general circulation, probably until the last one dies. And I forgive my sarcasm and editorializing here. For special meetings, these would be meetings that are not part of the regular schedule, but for whatever reason special meetings. You need to provide at least 24 hours notice that you're scheduling a special meeting. And again, that notice, it needs to be published in the paper and posted at the meeting site. There are no requirements for any sort of advance notification if you're canceling a meeting for whatever reason. Nevertheless, given the number of complaints that we receive, when a meeting is canceled without notification, put something up on the window or your door that tonight's meeting is canceled. Even though the person will still be upset, they may not be as upset because you at least put a notice up. Another important aspect, and where there's confusion, is public comment. Now, the public is entitled to public comment at a public meeting, but that's within reasonable limits. First is that the law allows a municipality to limit any commenters to being either taxpayers or residents of the jurisdiction that the public body oversees. Which means, let's say you have an environmental issue and you have a group coming in from outside the township that, you know, wants to comment at your meeting. Well, if they're not residents or taxpayers, you can basically prevent them from commenting. The public has a right to comment on any issue that's either before the board or expected to be before the board. And you must allow those comments before the board takes a vote. So I think you can see the intent of the public comment. Many times, and it's at your discretion as to how you arrange your public comment, but I've noticed that many municipalities will in effect have two comment periods. The first one will be specifically for issues that are before the board on the agenda or as they are preparing to vote on a proposal. so the public can line up and comment and limit their comments specifically to that issue. And then they have a second comment period, usually towards the end of the meeting, where they just open it up for general comments, criticisms, suggestions, and the like. That seems to work for them, but again, that's not a requirement that that's how the municipality administers its comment period. And the board can establish reasonable rules, meaning, for instance, time limits on comments. 3 minutes, 5 minutes, 10 minutes. Just make sure that you're consistent and equitable with it. It's surprising how often we hear that if the person agrees with the board, they get 10 minutes. If they disagree with the board, they're usually cut off after 20 seconds. Don't do that. Everybody gets the same time period. The other thing that you can do is if you have a committee or a citizens advocacy group, and you anticipate that all of the comments are pretty much going to cover the same thing, a repeat of the same points, the municipality can ask that committee, that group, to appoint a spokesperson. And that spokesperson would then be responsible for covering all the points. And maybe you would give them a little grace as far as the time periods or whatever. But you can ask them to appoint a spokesperson. Another area that's commonly complained about and that there appears to be a lot of misunderstanding is executive sessions. Now, essentially, an executive session is where the board is meeting, but they would meet behind closed doors in order to discuss specific sensitive topics. Now, an executive session can be held before, during, or after an open meeting. An executive session cannot be held independent or separate from an open meeting. Let's say that you were simply meeting, though, for a topic that clearly falls within executive session and there's no other business. It's awkward, but this is how you'd have to do it. You basically would advertise a public meeting 3 days in advance, date, time, and place. You would convene the meeting, call it to order, and then immediately go into executive session. You would hold executive session in private, conduct your business, then come out of executive session, and if there's no further business, you're back in public session, you would adjourn the public session without conducting any of the meeting, what essentially is a public meeting, in the public setting. I know it's awkward, but given the language in the law, this is what would be required to independently hold an executive session. But typically what happens is the board will meet ahead of time prior to the open meeting, or they may meet afterwards, or maybe even during a public meeting going into executive session. There is no requirement for minutes for an executive session. The reason that a board goes into executive session must be announced to the public, and it must be the complete reason. And I'll say that, the complete reason within reason. And we refer to a decision, it was the City of Reading versus the Reading Eagle, which is their local newspaper, where I believe it was City Council's practice to simply say, we're going into executive session for personnel reasons. Okay, the law basically said, or the decision basically said that's not good enough. The language is somewhat cryptic, but basically it says you have to give enough information for the public to know you're not going into executive session for the wrong reason. Okay, you figure that one out, but I mean, you can kind of see the logic behind it. So, like, if you're going into executive session for a disciplinary reason, because you've got, some staff who you're investigating or whatever, number one, there may be a union contract that basically says you will not publicly embarrass employees. So you've got to weigh that provision versus the law's requirement to give out as much information as you can to justify why you're going into executive session. That can be difficult. Also, just given the sensitivity of some topics, you've got to be careful with how much you say as a reason of why you're going into executive session. But simply saying, we're going to discuss a court case, that's not good enough. Usually you have to, if the suit has been filed, then you have to say what the case is. If you're discussing personnel issues, it may be we're considering reorganization. We're considering furloughs, something like that. Basically a general statement that gives a reason, a justification as to why the issue is sensitive and that the board has to go into executive session and weighing that against the need for discretion in many cases. It's not easy, but it's what the law requires and what the courts have said. No official action can be taken during an executive session, meaning there should not be any official votes. Rather, let's say that it's a disciplinary issue, and as part of the presentations or reports issued in executive session, the board decides that a suspension is warranted. Well, that's all kind of discussed in executive session, but the board must then come out of executive session into public session to take a vote to approve the suspension, if that's how, in fact, your board operates. Sometimes something like that would be delegated to, the manager or the HR shop or whatever. Executive sessions, the law allows them. The law allows 6 reasons as to why you can go into executive session. The first one is, personnel reasons. Hiring, firing, discipline, and the like. Discussing labor negotiations. Obviously, that's not something you would want to do in public. So the board can go into private session to listen to reports and discuss strategy and so forth. Considering the purchasing, leasing, or selling of property. Now, the word selling is not included in the Sunshine Act, but there's a court decision that says, well, yeah, it makes sense that the sale of property, in order to discuss valuations and strategies and so forth, you could do that in executive session, so that's approved. Consulting with counsel about any litigation or the threat of litigation. It's that issue of privilege, and that the communication between counsel and the board is considered at face value to be confidential. Therefore, going into executive session to discuss issues with your attorney is appropriate. As a matter of fact, avoiding violating privilege. Let's say that you are discussing an ordinance or a proposed ordinance, and there is a legal issue that it's not clear to the board, and someone looks over at the solicitor and said, well, Jim, what do you think? Well, by rights, Jim could ask that the board go into executive session because he is providing a legal opinion. Well, not a legal opinion, but an opinion at face value as to how he believes the board should proceed on a particular legal issue. He's providing legal advice to the board, which is, again, that communication is covered by privilege, and you could then go into executive session to avoid violating privilege, which would occur if that communication were shared outside of the attorney-client relationship. And then finally, there's one in there that the township board may not discuss university or can go into executive session to discuss university admission standards. I don't know. It's there. I guess that's important if you are on the board of a university. Okay, just some miscellaneous things regarding the Sunshine Act. The law requires, and I think the language is, you must keep minutes that record basically the date, time, and place of the meeting, which board members were in attendance, what issues came up, what business came up before the board, and how did they vote, yay or nay. There's no requirement in the Sunshine Act that a board either keep or distribute an agenda beforehand. But I'll be honest with you, we receive a lot of complaints about that because people don't necessarily know. They attend a board meeting and they're taken by surprise at some issue that comes up for a vote because there's no agenda. Well, the Sunshine Act doesn't require that a board have an agenda. The public is allowed to record public meetings, and they don't have to tell you that they are recording. Okay, there are provisions within the Pennsylvania wiretap law that exclude the recording of public meetings from any potential violation. So I can show up, with my cell phone and have it on record if I want to. I can have a recorder in my pocket. The presumption is that anything said during a public meeting is public. Therefore, it can be recorded. Agencies typically record their public meetings, and I think you can pretty much tell by the cameras around in this room that the meetings are recorded. Those recordings, whether audio or video, are considered public records as soon as the meeting has concluded. And this is where the two laws kind of cross paths, because I could file a right-to-know request for a recording of the public meeting, and it would be considered a record under the right-to-know law. Now, typically, the recordings are generated for purposes of producing the minutes to comply with the Sunshine Act. Now, as I said, the recording, as soon as the meeting's concluded, is a public record. But let's say the next day, the secretary sits down with the recording, which is essentially a verbatim transcript, if you will, in order to generate the minutes to comply with the Sunshine Act. Well, the minutes, as we'd found, are much more abridged. It's date, time, place of the meeting, who was here, what came up for business, how did they vote, and then usually there's something about public comment, or as the law says, testimony. So I draft those. Under the right-to-know law, those minutes are considered draft, and one of those exemptions exempts draft minutes from disclosure until the next regularly scheduled meeting of the board. At that time, the minutes are no longer draft. They become a permanent record, and the exemption no longer applies. The board does not have to vote to approve the minutes. Rather, the right-to-know law simply says, at the next regularly scheduled business meeting. Now, if we go back to the recording of the meeting, once I've generated those draft minutes, if I hit delete or record over or take the cassette and throw it in the trash, just to go back to the right-to-know law, I've not violated the law. Because if you remember, there's nothing in the right-to-know law concerning the retention of records. So just so you understand, the recordings are public records until they're destroyed. The minutes must be kept forever, and they are considered draft until the next regularly scheduled meeting, at which time they become permanent. And then they're discoverable under the right-to-know law as well. An agency can cure violations. What does that mean? Well, let's say, for whatever reason, a board goes into executive session. They have discussions, and they kind of resolve, okay, this is how we're going to proceed. When we convene out an open session, we'll take a vote, and then we'll move on. Well, let's say they come out of an executive session, and there's a distraction of some sort, and they get, off on a different track, and they forget to take the vote. And that night, the chairman is laying in bed thinking, oh my gosh, we forgot to vote. We clearly violated the Sunshine Act by, we agreed to something in executive session, but we never took the vote. And now we're enacting what we agreed to do. Well, you can reconvene the board, or maybe, if it's possible, wait until the next meeting and then vote. You've cured the violation, okay? As long as it's in good faith, it's an honest mistake. So the Sunshine Act allows you to do that, to go back and make it right. Now, if there is a member of the public who has a complaint, who believes you violated the Sunshine Act. There are no enforcement agencies. For instance, the Office of Open Records has no enforcement powers when it comes to the Sunshine Act. Rather, the ball is in the citizen's court. The citizen is required or obligated or, given the privilege of going to court and filing a complaint. And there's two ways to do this. First, if they believe that there's no criminal culpability, they can simply go down to the county court and file a request, an injunction, ask for injunctive relief, possibly, from usually the chief clerk, and it gets assigned to a judge, and they'll have a hearing if they feel it's necessary. Or if you believe there's possible criminal intent to willfully hide business from the public, then you can go to the district attorney and ask for them to conduct an investigation. And then the district attorney, for instance, we had a case up in, I want to say Sunbury, but that's not it. It's someplace close to It's up in Shamokin. I think it was Shamokin, where just last week there was a finding by the district attorney that yes, the Sunshine Act was violated, but there was no criminal intent. It was an honest mistake where basically the solicitor provided incorrect advice. And so the board acted, they did the wrong thing. But they were following the advice of the solicitor who misunderstood that aspect of the Sunshine Act. So, they'll only look at the criminal aspect of it. You can be fined for a violation of the Sunshine Act. However, it's not the township that's fined, it's the township official. And the township is not allowed to cover the cost of those fines. Rather, it comes out of the public official's pocket under the Sunshine Act if a fine is leveled. Okay, we're at the end of the session. I'll be here to take more questions, but before we conclude, I want to encourage anyone that has questions about either the Right to Know law or the Sunshine Act to visit the Office of Open Records website. There are a wealth of resources available there. The laws themselves can be downloaded in either PDF or Word format. We have guides available for citizens, agency open records officers, law enforcement, and the like. There are training videos on there that you can watch, learn various aspects of applying the Right to Know law, what to do if an appeal is filed, how to file an appeal, and the like. For the agency side, we talk about one of the best practices is use templates to save yourselves time. Well, we have an agency open records officer guidebook that's something like 78 pages, most of which are templates and forms that you can use to set up and administer your open records program. We also have phone lines and email accounts that are set up for anyone to call in with questions or issues that they're having related to administering or getting records that they're looking for through the Right to Know process. And we have two standards for the office that we're very good about. The first one is that if you call our office, you're going to talk to a human being. We do everything possible to make sure you're not getting voicemail. Now, occasionally around the lunch hour, we're trying to get something to eat, and for whatever reason, things pick up. I don't know why everyone has to call during lunch anyway, but it happens. So there's a possibility that you may end up getting voicemail then. But then comes the second standard, that if you email us or if you call and we don't have the answer for you right there, we will have an answer for you within 24 hours. If it means people have to stay up half the night, we will have an answer for you, because we know that if you're contacting us, number one, it's important, and number two, most likely it's time sensitive, because you're operating under the same tight deadlines that we are. So we're very good about meeting that standard. We cannot provide legal advice, but we can steer you towards decisions that we've made where the facts are very similar to what you're describing, to let you know how we've ruled on a similar case. And with a caseload or case history of 19,000 rulings, chances are there's something in there very similar to what you're asking us about. If it is something new, well, then honestly, you're going to get all kinds of attention because we love new stuff. And, you know, I think I've kind of, because of the tight deadlines tonight, or timeframes tonight, I haven't had a chance to tell a lot of stories, which is probably a good thing from your perspective. But, you know, we think we've seen it all, but we haven't. It's every day there's something new coming around the corner that takes us by surprise, and, you know, you get one of those moments. So we love new stuff. If you're a real geek about Right to Know, you can subscribe to our Twitter feed. Every morning, it's tweeted out, all the cases we are ruling on that day. The fact that I'm here this evening was tweeted last week. And you can sign up for our email account, where you can be emailed a summary of cases that have been issued that day. Every morning, I think it goes off around 8 o'clock or so. So everything you wanted to know about Right to Know can be right on your desktop, waiting for you every morning. But I sense from the questions that we've already received that you're on your game. You understand, you asked all the right questions, but I'll be available here to answer any further questions when we conclude. And if you need to, feel free to contact our office. And even if you want to ask for me, I'd be happy to talk to you and deal with any issues or questions that you might have. So I'll take some further questions. Go ahead. Got it.
So you mentioned at the beginning of the conversation about the Sunshine Law section that typically you know of municipalities having a public comment session at the beginning of their meeting that may be specific to the agenda or business before.
Well, not at the beginning,
business
but
before the
it has to
board.
occur prior to the vote. in
Correct,
some way.
prior to the vote, and then a second public comment at the end of the evening.
Yeah.
So how often do you come across a municipality that provides for a public comment before every single vote that is taken during the course of its business?
You know, if they don't have an agenda,
No,
I've
an
seen
agenda.
that. Well, even with an agenda, I have seen that. I've seen that. Usually, it's the items of big interest where they will have a separate and distinct comment period just for that particular issue.
No, I mean before every
I know,
single
I know,
vote. Is
I
that
know.
typical?
It's not typical, no.
Okay. So then you mentioned something earlier in the Right to Know that I wanted to just understand a little bit more clearly, which then leads into my sunshine question.
Okay.
You were referencing the situation where you have a personal email and you're mentioning to another board colleague that you were going to be late for the meeting. That's not considered a record under the Right to Know
Yes.
Act. Then you mentioned a situation where you are communicating with fellow board members and effectively deliberating in the email.
Yes.
Now, if you're deliberating with a number of board members that do not constitute the majority of the board, that's still a record, but is that a violation of the Sunshine Law?
Most likely it is.
Okay.
You're nevertheless deliberating. There was a case, now this goes back several years, with the city of Philadelphia. I think it was the street era, where council met in a large room, and in order to avoid it being a public meeting, they divided up into 4 groups. And the president of council went around to the different groups and deliberated with each group, but not as a whole. That was clearly a Sunshine Act violation.
Oh, so that actually leads to my question. So a situation where individual board members discuss as one-offs, you know, I speak to you, I speak to you, I speak to you, but
Yeah.
we become the majority in the
Consensus.
discussion outside of the public eye, and then write an email as a majority of the board to another board member issuing an ultimatum. Is that a violation of the Sunshine Act?
I would be very cautious of that sort of practice. I would be very cautious about any sort of email communications. Number one, because they are discoverable under the Right to Know law. And number two, because of the potential for a Sunshine Act violation.
And so
you
if
are,
they-
in essence, deliberating.
Great. So thank you very much. Are there any other? Thank you. Oh, did you? Oh, all right. Well, Anne Marie wants to go after me.
So I have a question. I'm not sure if it falls right under sunshine, but if a board takes a vote and there's a majority vote and nobody follows through on that vote, does that violate the Sunshine Act, or is that something different?
No, that's an administrative issue where,
not
you
under
know, if
that.
they say they're going to do one thing and don't do it, that's,
And so then when it comes to, I know you have experience with many agencies, and do you often find that when an agency has the ability to respond to something, that they might offer that? I mean, if it's a yes or no question or something, if you're at the lectern, if you're asking a question, that they might do their best to try to respond. I understand that, and not have them required to
in the
file
context of a
right-to-knows.
right-to-know request?
But just a general, what day
Okay.
is school getting out next year if they just happen to have that information but it hasn't been released?
Well, there's nothing preventing them from doing that, but
Okay.
there's no requirement that they must do that.
Okay.
During, as far as the Sunshine Act is concerned, during a public meeting, if I stand here during public comment and ask a question of the dais, they're not necessarily required to answer that question.
Okay.
Now, if they refuse, that's, you know, a different issue. But there's nothing in the Sunshine Act requiring that they answer
To
questions.
respond. Okay. Thank you.
Yeah.
On the question of public notice of the meetings, regular meetings, if I'm understanding correctly, the first meeting of the year that is a regular meeting, they're supposed to give 3 days' notice in the periodicals and posted at the location.
Yes.
And at that meeting, they're supposed to set the schedule of regular meetings
Well,
for the
they
remainder of the
can
year and
because it's
publish it?
their organizational meeting, or if they know ahead of time that we typically, historically have met on like the second Thursday of the month, then that would be posted with the initial
So
notice, either one.
all regular meetings for the year should be furnished at that time?
Yes.
So a board that typically meets 4 times a year and refuses to set a date for regular meetings, but ends up having them at some point and publishes them, make 2 days or 2 weeks or 3 days or whatever it is, you know, they're complying with the
Yeah.
publication, but it's really a regular meeting. It's just they're
Well-
refusing to set a schedule. Is that in a violation of some sort under
No,
this
as
act?
long as there's adequate advance notice that they're meeting, they're okay.
So even if it's a regular meeting,
Yeah.
or it's not really a regular meeting because
Well,
they didn't set,
you know,
I mean,
let's be-
are they required to have regular meetings?
If they're meeting quarterly, they may not, I'm gonna give them the benefit of the doubt. Maybe they can't know what their schedules are gonna be 3 months, 6 months, 9 months out. So
Okay.
they have to wait until we get closer to that date before we set the actual date and time of the meeting. And as long as there's at least 3 days advance notice published, then I think they're okay.
Okay, thank you.
Yeah.
Yes, if you're, we have a commission, and there's been a lot of effort to expand the activity and the agenda of the commission, and a lot of pressure to have other meetings, like, for instance, meetings of what we call subcommittee. We form subcommittees that are less than a quorum. Now, are they covered under the Sunshine Law?
Well, it would go under the standards that we talked about at the beginning. Are they conducting an essential government function? And are they providing recommendations to a higher level board?
So the fact that it was less than a quorum wouldn't
that has
change
no
anything?
bearing on it.
Would have no bearing on it? Okay, thank you.
You're welcome.
Thanks. I have a couple of executive session questions.
Okay.
The first relates to the personnel exemption. Absent a law or, as you mentioned, union contract or something that would have confidentiality, because the law was written such that the individual would have the right to have that discussion done in public as opposed to executive session, is there an obligation by the agency to notify those individuals prior to the executive session so they could exercise that right?
There's no obligation under the Sunshine Act, but under due process, most likely they would have legal recourse if they weren't given notice that a discussion like that were taking place.
And I'd have to look at the law itself, but I don't think the term discussion is used. I think it's something more intentional, like a hearing or some sort of formal inquest or inquiry that takes place that will result in a sanction of some sort. But I'd have to look at the law to find out that exact language. But essentially, to answer your question in a nutshell, regardless of the setting, whether it's executive session or just, you know, your HR department, labor relations people investigating, any employee or official that is facing a sanction of some sort has the right to due process, basically to be notified that we are investigating allegations against you and that they have a right to weigh in to provide mitigation for any potential sanction that might be taken. So that would apply to your board as well as whoever might be responsible for discipline within your organization.
Second question for executive sessions. If during executive session, a member of the agency thinks that a discussion is not suitable under one of the exemptions for executive session, what are both their obligations at that time and their rights potentially after that?
Well, at minimum, they would raise the issue saying, hey, I think this is inappropriate that we're discussing this in executive session. And I want it made part of the record, even though you're not required to keep a record. Okay, and then they may elect to stick around to see what happens, or they may excuse themselves from the meeting because they think it's inappropriate that we're talking about this. Usually that's what occurs. They get up and they leave. Then if they think any subsequent action has taken place as a result of that alleged violation, they have recourse before the courts, just as any citizen would have. And there are time limits, like this can't last forever. I think it's 30 days from the date of the alleged violation or a year from the date the violation occurred or allegedly occurred.
Thank you.
Yeah. We've covered it all, right on schedule too. Well, thank you all for your time this evening.